Hello everyone. Conveniently, our last few videos talked about the I-130. This is convenient because if you've been watching those, this video talks about a new policy USCIS announced on Friday, April 12, 2019, when minors are part of your I-130 application. My name is Raluca Hanea. I provide immigration, estate planning, and family law services to my clients in Lawrenceville, Georgia. Here with me is Nina Clear, my marketing and office manager. We really appreciate all your likes, shares, and comments as they help others to see our videos.
Okay, before we jump into today's topic, I really think we should mention this huge win that you had for a client recently.
Sure. I love to share things that I've been able to accomplish for my clients.
Okay, so your client came in and they had an NOID, and will you explain to us what that is?
Yes, an NOID is a notice of intent to deny.
And you've done a video about this before, but an NOID is much worse than an RFE, right?
Yes, it is. An RFE is a request for more evidence, implies that USCIS wants to approve you, but you need to convince them a little bit more. An NOID, on the other hand, says that they are planning to deny you unless you provide compelling evidence as to why they should not.
Okay, and this person received an NOID for what reason?
He was trying to obtain his conditional green card.
So what happened?
Well, not only did he get a green card, but he received his permanent green card. And I am so excited for him. And I'm proud that I was able to help him in what has been a very long process.
So people don't always get their permanent green card when they respond to an NOID, right?
No, the reason he received that is because USCIS took so long in processing his application.
And what do you mean by that?
Well, you receive a conditional green card when you're getting your when you get married and you haven't been married for more than 2 years at the time when you apply. And once you have been married for 2 years, you must apply to get your permanent green card. But since USCIS in this case took over 2 years to process his conditional green card, they went ahead and gave him directly a permanent green card. So now his next step is to apply for citizenship.
And I think it's also important to point out that he helped make your job easier too, right?
Yes, that's right.
And can you tell us what he did that made it easier?
Yes, the most important thing he did is that he has contacted me the day after he got his letter, his NOID.
And why was that important?
Well, it gave me the time that I needed to review all the documents he had and ask for more, and as well, he had time to gather all the supporting evidence to include with my legal brief.
So providing supporting evidence helped as well?
Absolutely. Without that, there isn't any point to respond.
And with that, you included some affidavits, right?
That's right. I find that to be very helpful if they are able to address the concerns that USCIS has.
And when you have those sent, you typically help your clients with them, right?
I do and I don't. I give them an example of one affidavit and I review those they submit, but I don't tell them what to say and I don't write it for them.
Why not?
Well, an affidavit is a declaration under oath, and it must be written by the person making that declaration. And yes, it is important that they address certain points in the affidavit, but I only advise them that they need to address those points in the declaration, but never write it for them. Each affidavit is a personal declaration, and it is written in the author's own style, and is describing the author's personal experience with the subject.
Okay, well, congratulations to you and to your client, but mostly to you right now for your hard work.
Thank you. So let's move on to today's topic.
Sure. Will you remind us all what an I-130 is?
The I-130 is the petition that is filed to show the relationship that you have with a person who is not a U.S. citizen or green card holder and who wants to immigrate in the United States.
And as we discussed previously, the I-130 itself has to be filed in the U.S., right?
That's right. There are a few exceptional circumstances, but for the majority of applications, they must be filed here in the U.S.
And we've mentioned that the I-130 is the first step in obtaining a green card for your relative, right?
Right. It seems to confuse people. The I-130 is filled out and is filed as a first step when applying for a green card. But its approval does not give you a green card. It basically says your relative, spouse, sibling, child, or parent is approved to get a visa to come to and stay in the United States. But now we, meaning the immigration agency, we will process their green card application.
And typically a green card application was filed at the same time as the I-130, right?
Usually, yes, if the beneficiary is living in the U.S., and that is called concurrent filing. It's always hard to pronounce that. But if the beneficiary is living outside the United States, the State Department has additional forms you will need to fill out.
Okay, so tell us what this new policy is.
Sure. These may apply to very few people, but if one of the applicants, a spouse or fiance, is under 16 or is age 16 or 17, and there is a 10-year age difference between the couple, then there are special considerations that USCIS is now going to implement.
And what does that mean, special considerations?
Based on the policy alert issued by USCIS, as we said, in April the 12th, 2019, their system is now going to flag any couples who have the above conditions.
And what do you mean by those conditions? So that means the one person in the couple is either under 16 or 16 or 17, and the other one is like 26 or 27 or older.
Right.
Okay. Do you know what flagging their file does?
Well, first, it sends it to a special unit to verify if the ages are correct, if the date of birth on the application are correct. Then, if they are not, the application will be rejected. And if they are, then they will have an in-person interview conducted at an earlier stage in the process.
And what did they do previously?
Well, they had the same interview policy as other I-130 applications, where they interview the applicants here in the U.S. or at the consulate when they apply to adjust their status for an immigrant visa. But now they will have an additional interview earlier in the process.
And has anything else changed?
Yes. One thing that they are doing is determining if the marriage is legal, where it took place, and it's based on the youngest spouse's age.
Okay. Anything else?
Yes. They will also evaluate the marriage if the marriage is legal in the United States and the state in which the couple resides and or is planning to reside. Interestingly, even if the marriage is legal, if it is considered offensive to the public policy of the United States or the state in which they will reside, it will not be recognized as valid.
And what do you think that means?
Well, some states allow marriage with minor children with parental permission. USCIS has directed its staff to review the specific state criminal statutes that penalize undesirable or offensive conduct. They also explain that some people get married outside of a state to avoid the laws of the residential state, which may now allow marriage, which may not actually allow the marriage with a minor. And if they determine that this is what this couple did, USCIS has directed the staff to deny the application.
Okay, so what has remained the same?
Well, as with any benefit, the burden is on the petitioner to demonstrate the validity of their petition and the bona fides of their spousal relationship.
And when does this policy go into effect?
It goes into effect immediately.
And is there anything else that people should know about it?
When you file an I-130, you usually submit an I-864, and while the I-130 does not have any age requirements, an I-864 requires that the applicant must be 18 or older.
Okay. Do you know what types of questions they'll ask at this new interview?
It will be similar to the question asked during the I-485 interview. However, due to the concern about human trafficking as well as interviewing minors, USCIS has told their staff to consider having a support person attend the interview for the minor and to build rapport with the person being questioned. Keep in mind, this may be a very small number of applicants. I have had a few clients who have been under 18 before they got married, but the majority are over 18. Thank you for watching and really appreciate your likes and comments. If you have any questions, please reach out to us as we are always here to help. See you later.